At the conclusion of this lecture, you will understand the need for consideration, understand what is meant by adequacy and sufficiency of consideration, and understand how an offer or contract can be terminated. In common law, a promise is not, as a general rule, as binding as a contract, unless it is supported by consideration. Consideration is something of value, which is given for a promise and is required in order to make the promise enforceable as a contract. This is, traditionally, either some detriment to the promisee, in that he may give value, and or some benefit to the promisor, in that he may receive value. For example, payment by a buyer is consideration for the seller's promise to deliver goods, and delivery of goods is consideration for the buyer's promise to pay. An informal promise does not amount to a contract, as consideration is deemed not to be given by either party. The traditional definition of consideration, as set out in Currie v. Misa, 1875. A valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit accruing to the one party, or some forbearance, detriment, loss of responsibility given, suffered, or undertaken by the other. The doctrine of Promissory Estoppel is an equitable remedy that was developed by the courts to protect the rights and interests of persons who, under a promise, relied upon the requirements of the promise to his or her detriment, regardless of whether consideration was provided. In unilateral contracts, the parties do not exchange promises. Only one party will make the promise, and an obligation will only arise if the other party carries out the specified acts. Consideration for the promise is not executory because the act has not been promised by the promisee. If the promisee chooses to and does perform the specified acts, the consideration is executed. Example of unilateral contracts include notices for awards. In bilateral contracts, the consideration is considered executory. Each party exchanges promises with the other to do or to refrain from doing an act. This means that the obligation to perform has not yet fallen due. Therefore, the consideration is executory. There are 3 rules that are used by the courts to determine whether consideration is adequate. We will now examine each in turn. The first rule provides that consideration must be sufficient, but need not be adequate. The requirement that consideration must be sufficient means that what is being put forward must be something which the courts will recognize as legally capable of constituting consideration. The fact that it need not be adequate indicates that the courts are not generally interested in whether there is a match in value for what is being offered by each party. The case of Thomas v. Thomas in 1842 is relevant here. Thus, nominal consideration is sufficient. The second rule relates to the fact that consideration must move from the promisee. The promisee must provide the consideration. Traditionally, a person to whom a promise was made can enforce it only if he himself provided the consideration for it. He has no such right if the consideration moved from a third party. In order to better understand this rule, see the following rule. If A promises B to pay £10,000 to B if C will paint A's house, and C does so, B cannot enforce A's promise, unless B had procured C to do the work. However, where the conditions of the Contracts, Rights of Third Parties Act 1999 are met, a third party may be able to enforce rights created in his favor by a contract which he was not party to, and the courts are also adopting a more flexible position under the common law here. It will generally be the case that consideration moves from the promisee to the promisor. However, it is sufficient if consideration moves from the promisee to a third party at the direction of the promisor. When a promise is made to joint promisees, it is enough if consideration is given by one on behalf of all, because it is then deemed to have moved from all. The doctrine of privity provides that only a person who is a party to a contract can sue as a result of it. A promisee is only able to sue on a promise if the promisee has given consideration for the promise. The third rule regarding the adequacy of consideration is the consideration provided should not be in the past. the consideration will be regarded as being past if it has already flowed from the promisee to the promisor prior to the agreement being entered into. The rule is that past consideration is no consideration, so it is not valid and cannot be used to sue on a contract. For example, A gives B a lift home in his car. On arrival, B promises to give A £5 towards the petrol. A cannot enforce this promise as his consideration, giving B a lift, is past. For another practical example, see the case of Re McCardle, 1951. There are a few exceptions to the general rule that past consideration is no consideration. Previous request. Here, if the promisor has previously asked the other party to provide goods or services, then a promise made after they are provided will be treated as binding. Business situations. Here, if something is done in a business context and it is clearly understood by both sides that it will be paid for, then past consideration will be valid. See the case of R.E. Casey's Patents, 1892. Under Section 27, Part 1, it is provided that any previous liability is valid consideration for a bill of exchange. For example, A mows B's lawn, and a week later, B gives A cheque for £10. A's work is valid consideration in exchange for the cheque. Another exception to the requirement for consideration can be seen in how the law views deeds. Formal agreements that are signed under seal are referred to as deeds. Because of the seriousness of the manner of execution of such documents, the common law has recognized these agreements as valid, even if the consideration has not been provided. Revocation is the formal withdrawal of the offer by the offeror. Before acceptance, an offer can be freely revoked. However, once the offer is accepted, it cannot be revoked. See the case of Routledge v. Grant, 1828. In unilateral contracts, the offer cannot be withdrawn after the offeree has begun to perform the necessary conditions of acceptance of the offer. The rejection must be communicated to the offerer before it is effective. Once rejected, an offer cannot be later accepted. If an offeree attempts to accept the offer but introduces new terms, the offeree is rejected the offer and is deemed to be making a counter-offer. Offers lapse and are no longer capable of acceptance in the following circumstances. At the end of a stated period, it is possible for the parties to agree, or for the offerer to set a time limit within which acceptance has to take place. If the offeree has not accepted the offer within that period, the offer lapses and can no longer be accepted. After a reasonable time, where no time limit is set, then an offer will lapse after the passage of a reasonable time. What amounts to a reasonable time is, of course, dependent on the particular circumstances of each case. Where the offerer dies and the contract was one of a personal nature, in such circumstances the offer automatically comes to an end, but the outcome is less certain in relation to contracts that are not of a personal nature. This is known as an option contract, and the offeree must provide consideration for the promise to keep the offer open. If the offeree does not provide any consideration for the offer to be kept open, then the original offerer is at liberty to withdraw the offer at any time. See the case of Routledge v. Grant. Where the offeree finds out about the withdrawal of an offer from a reliable third party, the revocation is effective and the offeree can no longer seek to accept the original offer. See Dickinson v. Dodds, 1876. If a condition upon which the offer is made is not fulfilled, the offer will lapse. If the offerer dies, and the offeree has not been notified of that death, it is still possible for the offeree to accept the offer, thus binding the offerer's estate. If the offeree has been notified of the death, he or she cannot accept the offer. See the case of Coulthard v. Clemenson. A representative of the offerer's estate cannot accept the offer on their behalf once the person who has made the offer, i.e., the offerer, has died. In conclusion, you will now be familiar with the following concepts. Consideration must be present before a contract is legally enforceable. Consideration may be nominal. Consideration must not be in the past. Need not be adequate, and must flow from the promisee. Finally, you will be aware of the numerous ways in which an offer can be terminated before it is deemed to be a contract.